states and different statutes in our subcontracts because they are state specific. So if you guys would, welcome Kevin and Chad.
Thank you. So we've kind of divided this up where I'm going to take you through the formation of the subcontract, walk you through some critical items in terms of the administration of the subcontract, and then Chad really is going to spend more time on various changes that have happened statewide, lien laws, things of that sort. One of the things that we did a while back was we changed your subcontract from, I think I've represented you guys for not quite 20 years, but when I first started representing you guys, you had a state-specific subcontract form. So if you were in Tennessee, you had to go get the Tennessee form, Georgia form, etc. We did away with that, and we moved it to a common subcontract with state-specific inserts. And the way that we did that was by going to this Exhibit A-driven approach, which is the scope of work. Within the scope of work, it's state-specific changes, okay? So, for example, in Tennessee, where there are different retainage requirements, that's where you'd expect to see that kind of process. So before I kind of go through your subcontract as a whole, I'm more interested in hearing from you two things. You guys have switched to a new software program. That has been a protracted process. I would like to know how that rollout is going and how that is interfacing with your subcontract. Because while I've had discussions with Rice and others about it, I need to hear from you guys about it because it very much relates to the administration piece. The second thing that I want to hear is actually from the project administrators, because you're the ones who probably are putting together these subcontracts. And how is that process going in terms of ease, efficiency, knowing what's what? Because the goal was that instead of having project managers who had experience with various scopes of work from prior dealings on prior projects, and therefore everybody had their own way of doing it, that you guys were supposed to come to some kind of collective agreement on general scopes of work, trade-specific scopes of work. Has that happened? Is it a source of frustration or not? So those are the things I'd like to hear first, because while going through this subcontract is fascinating to me and boring perhaps to you, it is, at the end of the day, only going to be meaningful if we give you something that's usable to you, right? So the first thing that I want to do is I want to hear about functionality. How's it going? Benning's growing as a company. You're growing in terms of projects. That's all positive. But at the same time, subcontractors are out of control busy, and there are a lot of subcontractor issues that we're going to talk about. So let's go back to where my two questions. Software, rollout, where do we stand, interface with the subcontract? You want to take it, John?
I will take as much as I can here. Anthony's probably more up to speed. Rollout right now, I think we've got just about every project since the beginning of the year, outside of Mr. Benning's 2 or 3 jobs, are now on the new Vista software. There are some folks that have 8 months to a year's experience on it. There are others that are green as can be. I'm one of those. So it is a learning process. There are similarities and dissimilarities and efficiencies and things that are not quite as efficient. Within the subcontract and the buyout, it's a different approach. I can see efficiencies there now that I'm starting to get the knack of it from my end, where we are writing in the Article 1s or the scopes, and we're checking boxes or unchecking boxes, and then from there, it mysteriously disappears, and the admins are actually getting these contracts out. And Kat or Catherine, or if you guys want to kind of comment on what you guys are seeing on your end, because obviously y'all are the ones that have the most work with these contracts and purchase orders to the subs and vendors.
Our part of it is relatively easy. We get the email that says send them out. We check spelling errors and the Article 1s and send them out, email them. There's nothing to it on our part. I guess the biggest challenge that is involved in this is with Mona and I when we have to put all of the stuff into the fields, into Vista, so that they're automatically generated. That is extremely time consuming.
Okay.
And, but that's it. I mean, it's relatively easy on our end.
And so basically, you're creating the template on the front end.
Mona and I, well, they put them in there, but they weren't,
They weren't right, so
They
we
were
had to
not right.
redo them.
Okay. But that was the first time, or that's each time?
no, once we get them in there, it's good.
Okay.
But we just have
And
to
then once
keep
that's done,
everything.
it's faster, easier?
From our end, yes, except, well, yeah, the front end, yes, it's much faster and easier on the front
Okay. Okay. Kevin, does that answer?
It does, I think. The,
end. It is much faster and easier.
the Article 1, is that what references back to the Exhibit A scope of work?
Yeah. Yeah. And
So I think the goal, and I don't know how to make this happen, but the goal that we've been attempting with you guys is to get buy-in from the team on what are the general scopes of work that ought to be in every single subcontract. Those apply regardless of trade, okay? So would those have to be checked in the Vista software, or are we talking about specific trade scopes?
We're talking about specific trade scopes, so we're talking about the scope relative to electrical, to masonry, to plumbing, et cetera. I know beyond that, in the lower portion of Article 1, we do have some very general requirements, such as layout, substrates, if you start applying on a substrate, protecting other surfaces. So a lot of those are already in there. But the trade-specific scopes vary enough within the projects, and the deals cut, negotiated on bid day within the projects, that even though a Publix is a Publix and a retail shop is a retail shop, those are still specific, so there are adds and takeaways from those generalized scopes of work.
Okay, so the process now is that the PM or estimator is building that, and then that is getting checked off in the software system?
So basically, the ladies are preparing the template on the front end, and then the PM or estimator are preparing the scope of work that then gets generated into that template, and then everything is sent out as a package.
Okay. Well, everything that we're talking about today in this subcontract, every single thing in terms of how to administer the subcontract, ultimately ties back to this discussion that we're having right now. If you don't have your scope of work correct in terms of your buyout of the project, then you are guaranteed to have at least two problems on every job. More money from a sub due to change orders, more time due to change orders. So from the very beginning and inception of how you build this contract, from estimating to what's in and out of the contract, that's what you need to be thinking about. So scope of work drives the entire thing. It might sound simple, yet it is the area that often gets rushed because you are trying to get some subcontractor in place, meet a bid, do this, that, and the other, and therefore things get missed. It's for that reason that what we're trying to do is create some kind of workable, repetitive, common system. And what I can't quite ascertain, but I'm leaving it to you to tell us, is whether your software is helping you with that process. Because what we did is we tried to create that template for you on this Exhibit A. All that template has done is moved into some software realm. Okay, that's fine, as long as it's not completely destroyed by the negotiation process, then it works. But those general requirements that ought to be on every job, which is namely, if you put your work on top of existing work, you take responsibility for that work, that general concept should not change. I mean, the general conditions that exist across trades should be no reason to visit that. And if there is getting modification of that, there somehow needs to be a process to alert from the PM or estimator level, if you're going to modify that, there has to be some kind of method for addressing it.
I think that's happening on the handoff between the pre-construction and the PMs now. They're sitting down and reviewing scopes with that they've negotiated with the trades when they're doing the buyouts of the jobs now.
Perfect.
Yeah, but, sorry, I still don't think we have a database for Article 1's scope of works that you're asking.
do or do not?
We do not, to my knowledge.
Oh, a standard scope, no, we don't have a standard scope of Article Ones.
Right, we don't have that database.
Okay, I would strongly encourage you to do that. Now, that is something that Chad and I can help you create. We represent, 50-plus general contractors. We know what they are. But what's going to be different is that for XYZ general contractor, their general terms and conditions might apply because, say, they do more industrial work. So yours is going to be different because you're going to have specific terms and conditions that are going to apply because you do more retail work as a predominant basis. What cannot happen then, if you want to be successful long-term with these subs, what cannot happen is a lack of continuity in this. I mean, if you don't have your database, then what's happening is your PM, who may come out of binning or may come out of some other project, has got a little drawer or underneath their desk of terms and conditions they've used on prior contracts that they start shoving into this. And it's not terms and conditions that are scope of work. It's terms and conditions that are actually undoing all the terms and conditions that Chad and I have been busting our ass for 20 years plus drafting for you, because they're like, you know what, we need to better, golly, we better address that pay if paid, let's throw that into the scope of work. Better address indemnity, because that's going to be important, let's throw that into scope of work. And every single general contractor that I sit down with, including their general counsel, nationwide has the exact same problem. So, as an organization, now that you have a software system which should be giving you uniformity, and I had this conversation prior to the software about a year ago, I told you then, sit down, take the time, and come up with a common set of general terms and conditions for scope of work. And then accept that the terms and conditions that are in this subcontract, right, which we've changed our approach with you guys, because while I'm going to talk you through this, we've moved to kind of a project administration services with you, where you guys, if you've got a project, you've got issues, you can pick up the phone and call us, because this training retention period on this subcontract, depending on the individual, is going to last in your brain somewhere between a week to a month before you're on to something else. Because there's just no reason for you to retain all of this unless you're in our business. But if you're administering it, if some issue's coming up that relates to the contract, then it's going to matter more. But what I'm trying to do is go past all of that and tell you how to win without regard to looking back at your contract. If you want to not look at your contract, which I imagine if I asked for a show of hands, who would like not to look at their contract while the construction's going on, I would get 100% attendance in that. If you want not to do that, then follow this approach. Get a unified set of conditions, because you can't rely on the admins for that. They're only doing what you send to them. That's exactly what we heard. Their job's easy. I spell check it and send it out. Well, what's getting sent out? If you don't know the answer to that question, and if the answer to that question isn't that it's a unified, agreed upon binning set of general conditions for every trade, then you're creating problems on your job without even realizing. So I can spend all the time in the world telling you how to do a contractor's decision and what the implications of claims are, yada, yada, yada. Doesn't matter if your scope of work is wrong. Okay?
Okay, I think you're talking about one thing and they're talking about something else. As far as, you're talking about the generalized, that is in every contract, every scope that goes in and just sits in the boilerplate, and we do that. Where I think what we're talking about is this very specific to that specific contractor.
Actually, I'm talking about both. The general terms that are common to all trades is one aspect of it. But there is an ability for an electrical sub, and you guys could meet right this second and say, without regard to what we're going to carve out of that trade, what is common to the electrical trade? What is common to the plumbing trade? What is common to the HVAC trade? What is common to the concrete sub, right? That kind of commonality, it's both. So while you're correct that ultimately the rubber meets the road on the specific trade, and that's where a lot more of the negotiations go on, the problem I'm talking about is not limited to that. I'm telling you right now, the problem that I'm talking about, I'm not naming names in here, not even saying it's going on in here. I'm just talking about in construction in general. The number of times that I see somebody mark up general scopes of work and start putting in terms and conditions and other things and qualifiers is astounding. It's a big problem. It's undoing your subcontract. So, yes, you must have come to an accord on what's the electrical scope of work. Absolutely don't disagree with that. But
You're saying the Article 1 proposes the scope and the general terms.
Article 1 is composed of two scopes of work. It's composed of the general scope of work, which is common to every trade, and it's composed of the specific trade scope of work. Technically, it should have a few other things in there, like how are you going to deal specifically with the schedule of that. But I mean, those are the two scopes of work that are common. The first one of those should be, is there any doubt that the first one of those should be an agreement of binning that you have as a form document that you can put into every single one of your subcontracts? I don't know. What do you think?
I mean, I think we can have general terms for each sub, you know, clean up all your work at the end of the day kind of thing. Just a general list that we can comprise.
So, it sounds like.
Yeah,
we should-
that doesn't seem common, is it?
Quite a bit of that is, Kevin, because we've got a section, and they're not in here, but we've got a section of about 18 to 20 items that are common like that,
Yeah.
that are added to the bottom of the specified scope of work that we put in. We may be able to expand on those, and we probably should expand on those, but we do have about 18 or 20 items.
Those 18 to 20 ought to be automatic in your software, that's what I'm saying.
And I believe they are, so
They are.
and that's items like layout, cleanup, protection of other surfaces,
Correct.
acceptance of the substrate that you're working on, that sort of thing.
Perfect.
Okay.
As long as you've achieved that,
What we haven't done is we haven't gone out and said, okay, a generalized electrical scope of work should be all secondary feeders from the transformer to the switchgear location, all switchgear, all conduits, all wiring. We haven't done that because that can change. It could be aluminum in one, it could be copper in another. The switchgear may be supplied by the tenant, it may be supplied by them. They may be responsible for low voltage, or they may not be responsible for low voltage. They may provide, and so those we haven't attacked because I think there's still quite a bit of change that we'll end up with a bunch of red lines coming back, more so than we already get. Now, we can take a stab at that and then identify below or do a checklist to, if nothing else, create a full final that we can use as a checklist and then remove or add to as necessary. And that sounds like that's where we need to go with it.
yes, if you've gotten past the general conditions, which it sounds like you have,
Yes, sir.
then the next step is commonality on what you would expect to see for specific trades.
Right.
Given the fact that you're a preferred public contractor, at least on the publics, I can't imagine you wouldn't have some that aren't going to change no matter what.
Yeah, and I think it would be specifically do Publix related, retail shop related, theater related. So if we got those three, it could be in a database that, especially for the younger guys or the newer folks new to the company, they've got something to check against rather than actually going back and looking through a bunch of contracts to find something for commonality.
What I don't want you guys to do is I don't want you attaching the subcontractor's clarification proposal and assumptions to your documents. But some of those assumptions, some of those may get baked into the specific scope of work, right? I mean, because oftentimes what the sub does is in the process of going through that clarification and assumption, they start rewriting basic terms and conditions of your subcontract, which is not the way to do it, right? You want to do that specifically. Okay, so I like that. I think that's progress. I just want to make sure that what you come out with after going through all the headache of the software change is you come out with something that gives somebody, in your words, a checklist, in my words, perhaps a template, whatever the words are. You shouldn't have to reinvent the wheel with every electrical sub. There ought to be a universe from which Bennett says, this is what we do, as opposed to picking up the last electrical subcontract and saying, did it that way the last time, whether that was how Benning wanted to do it or not, and we're gonna do it that way this time. Any questions about that? No? Okay. So that's really where I wanna see you guys move, because the rest of it, your subcontract is set up in a fairly straightforward way of trying to arm you with the necessary tools to accomplish the relationship with the sub, because without the relationship with the sub, you know, if all you're doing is cramming down on subs 100% of the time, you eventually have no subs, and therefore you're not going to be building anything, right? So we're mindful of that. You have to have a relationship with the sub. But at the same time, you're the intermediary between the sub and the owner. So ultimately, the sub, while it may have some issues with Benning, if the sub has issues with the plans or other things, then there are things within this subcontract to help you deal with the owner on that as well, okay? And as long as we have specific and agreed upon scopes of work, then the time and cost of what you should reasonably expect shouldn't be an issue. Agree on that? Any other questions about that before I just kind of run through how this subcontract is laid out again so that you can understand how we try to administer this thing? Because this is really, the message I'm trying to get across here is that you can prevent a lot of disputes at the buyout estimating stage of your subcontract by following this process. And if you prevent those disputes at that time, then a lot of what I'm about to talk about is not going to happen, because you have communication, you have agreement, you have buy-in as to what they're supposed to do, right? I mean, look, it's a chaotic environment, so I mean, construction is gonna go haywire at some level, like we all appreciate that. I mean, so this is just trying to control what we can control, okay? Questions or issues before I go forward with that? Get him engaged. So while he's doing that, I'm just going to I'm going to move to a secondary issue that I just want you to be mindful of, and that is your contract, all the way back to the junior days, and probably prior to junior, prohibits assignment of the subcontractor work. The idea is that you actually know who you're having perform the work. We all agree on that? How many of you think that's actually what's going on? That the person that signed your subcontract is actually the entity doing the work? Anybody? We all know it isn't. We all know that a large part of what's happened is that it used to just be second-tier subs, but now it's gotten far worse than that. Now it's gotten to the point of labor brokers, factoring relationships. I mean, the complexity of what's gone on in the subcontract market is extreme, and it is the #1 risk to success of your operation. So, from the PM to the superintendent on down, making sure that you are actually evaluating the quality of the work that's going on and not relying on the supervision being provided by the subcontractor is probably more paramount today than it ever has been. As far as making sure that the subcontractor actually provides a superintendent on a regular basis, it is essential. So if there's nothing else that I convey to you today in terms of what you should do differently on your job as you walk out there, it's that. Go out there and make sure you know who is the superintendent for each trade that is out there and what are they doing to make sure that those trades are actually performing. Is there a superintendent from the trade? Because the number of times that Chad and I've had that recently is astonishing, where the trade shows up with no superintendent.
I mean, they'll throw a foreman out there, or what they call a foreman out there, but
Not a superintendent.
foreman's basically just another worker.
The guy that drove
It's
the
not-
truck
yeah,
for everybody else.
And
Right.
related to that is this issue, where they say, well, you know, we had this crew and they achieved this level of completion, but everything else is punch work. And in fact, what they're calling punch work, anybody else would say, that damn sure seems like base building work. As a matter of fact, if you try and deal with it on a punch basis, you're gonna have huge problems because the amount of corrective work might exceed the amount of time of the original work. Why do they wanna call it punch work? Because if they call it punch work, they met your schedule. But if the punch work takes longer than the original construction, you're off schedule, right? And we've seen that on numerous projects. I mean, framers, you don't do stick build, but I mean, in the framing industry, it's a serious problem, okay? But it's not limited to that. Drywall, all of them have kind of moved to that, and it's part of the labor broker problem.
And the other issue you have with that is when they send it in there, they'll say it's punch work. At the end of the job, they'll send a 2-man punch crew that's less experienced and not as qualified as the initial guys who threw it up in the first place. So you're not getting the best product either. You're getting faulty work that's getting fixed after the fact.
But you bought out your job based on assumptions about labor productivity. I mean, whoever's doing the estimating in here is evaluating how much labor is going to achieve what production requirements. That's how you build a schedule. None of that is happening if they aren't adhering to that. So why are we saying that this is the most important thing? Because it's the thing you've got to get on top of immediately, right? I mean, you write it down in daily reports, you can submit a claim, but you have to evaluate whether that's going to result in acceleration of your schedule earlier in time than at any point probably in the entire time you've been doing construction. Because depending on what the trade is, depending on the impact on the critical path, you may be going vertical in your schedule without even realizing you're going vertical in the schedule because of what's happening with that. Okay? So, go out today and talk to all the superintendents from Benning and make sure that you are on top of that issue, okay? Because it matters more than anything. Because I cannot give you any solution to labor brokers. I wish I could. I wish I could tell you, okay, here's how you can spot a labor broker, and here's what you can do about it. I can't. They're good at it, sir.
This is kind of off this a little bit, but we had a scaffolding accident earlier this year, and OSHA showed up. And OSHA started talking to the block masons. Well, come to find out, there was two different subcontractors working for the company that had the contract. And the last we heard is that we didn't receive a citation or anything, but I think the masonry subcontractor and one of the subs of the sub of a sub were listed as being reviewed by OSHA. So the interesting thing, it got into a point with like, who's responsible for what dealing with this as far as it goes. And I'd never really seen that before because always it's been us and the sub versus a sub of a sub being reviewed from the safety standpoint of things.
So Maurice, you're saying that the first tier sub, the one we contracted with, was held with the general duty clause? Is that what you're saying?
I'm not sure if they were held with the general duty clause or the specifics, I can look it up, but they are listed as being reviewed. And what citations have been issued, I don't know, but Lisa was telling me about which one of the two subs was also on the list. I've never looked at that, but we did look at the masonry contract. It's out there.
So that point is a good one because it underscores why you had the subcontract to begin with, because it obligates all of them to follow those kinds of safety procedures. But it goes exactly to the heart of knowing who's on your job, right? And knowing who's doing what, because I presume you, like most of the general contractors, have daily safety meetings and you make sure that people are safety certified on your job, right? And nobody's supposed to be allowed out on your job unless they've gone through your safety training regimen. Would that be correct?
We have a weekly toolbox talk, which the superintendent holds usually Monday or Tuesday mornings at the progression of the shift, and goes over things that are specific to what's going on, ladders or scaffolds or excavations, things of that nature.
What about this concept of making sure that anybody that's on your job has been through safety certification and training before they're allowed to get out there and do work? How do you do that?
We through the contract, we require that people follow OSHA, and that may require a competent person for that specific trade.
But is binning itself?
You're referring to safety orientations like day ones, that is not happening right now.
Correct. Any plan to do that?
I haven't looked into that, Kevin, to be honest with you.
Well, it's something to consider. I think it is going to bolster your position on something like OSHA if you're doing something like that, because it shows that you are at the forefront of knowing who's on your job and trying to make sure that they're certified. I think they give stickers or something,
We
there are
check.
various ways of doing it.
We check the basic safety as far as people on forklifts, competent person, scaffolding, and things. But with the number of projects we run in a year, there's no way that, that looking at full-blown safety for every subcontractor and trade that they've got, have they got HAZCOM, or are they doing PPE or stuff? We don't have the manpower to do that. And there's also the liability to a certain extent of, if we start doing more of the basic toolbox safety training for some of these guys, we are taking the liability of more of getting away from more specific versus the multi-sided employer policy that's out there. And I mean, we're running 40, 50 projects a year. There's only so much that the superintendent's going to look at, but we do hit the basics of what's there. Have you got it? Have you got a safety manual? Are your people, if they're putting scaffold together, they know what they're doing. If they're driving the forklifts or whatever, are they tied off? Have they had fall protection training? So yes, we do that. But we are not doing safety training for the subcontract. We do make suggestions on it, tell them where to go, but we're not issuing forklift cards and such.
I think what he's referring to is something different.
It is.
Yeah,
Yeah, I'm
he's
not,
referring
I
to
don't want you being in the training business.
Day
I'm just-
one safety
It's just a
orientation
briefing
for every new worker on the
orientation.
job.
Yeah.
So that we discuss the safety on this job, we discuss the site-specific procedures on this job, access, and everybody that comes on that job does that day one, so that, and anybody can walk around and see have they gone through it, because there'll be a sticker on their hat or not. As we start doing bigger jobs, that's gonna become more and more necessary.
It's not even going to become necessary, it's going to become an obligation, whether it's in your existing owner contracts or not. I suspect it probably is, even though you're not doing this orientation, that it is absolutely, you start doing bigger jobs, this orientation is mandatory. So it's not training, it's just this orientation, which it sounds like he's familiar with, that I think you need to put that on a follow-up box, because I suspect that obligation exists in your owner contracts now. And in the absence of doing it, you may have an OSHA problem. But the other advantage of doing it is that it gets to this labor broker issue, because you are, by virtue of doing this orientation, they're having to disclose who's their superintendent and how is that superintendent communicating with these various laborers on the job. So it gives you some control over the job that's different. I generally don't see this being done by the superintendent or even necessarily the project manager. I generally see this done either by a junior superintendent or somebody at that level who's got a very specific script that they're doing, because it's not, you're basically just going through what amounts to a 5-10 minute presentation. I was at a power plant on a big case that I have, and I mean, they just rolled out a PowerPoint, took all about 5 or 10 minutes. We weren't allowed to go outside until we watched it. And the guy running the PowerPoint, I mean, wasn't there to give us any insight. It was, in the event of a blow up, here's where you run to, kind of stuff. So the, that kind of thing would be meaningful and would at least give you a little more control. Maybe you could do it the same way. I mean, just run a PowerPoint or something.
So one of the things that I think we're going to walk through a couple slides here on is you're buying out your subcontract. Before you start to work, what have you got to get from your subcontractor? What physical documents do you need to get from your subcontractor before they set foot on your job? And this is a check the box requirement, but it also walks you through some of the key provisions of the subcontractor as well. So,
And it's gonna tell you something right away about your sub. Because if the sub is not readily showing up with certificates of insurance, start saying, well, I'll get that to you, you know, let me get going, I'll get it to you. Or they're not readily showing up if it's a bonded job, you've got an issue with the sub that you need to pay attention to. Because the reason for, in the case of a bonded job, is that it's a function of financial solvency of that subcontractor. I mean, you're gonna know how extended that sub is in a second if they can't provide the bond. I don't know how many bonded jobs you do, I don't think it says you do all that many. But on the insurance side, you wanna make sure you have that certificate of insurance, and the way it's set up in, and this is what gives you the leverage to obtain this, the way it is set up in your subcontract, is these are preconditions to first payment. So they have to provide that so that you can get paid. Okay? Questions about that?
next big item you want to make sure you've got, and this is more important in certain states, but it's important, you know, in all
Tennessee,
states,
Alabama.
is licensing information. And you've got to get this, I've got a chart here that I put together for you, kind of summarizes kind of basics about state contractor licensing requirements. This isn't business licenses, this is just the contractor licenses. Some states also require that you have a business license in the jurisdiction, like Alabama. But here, the key states that I want to make sure you're paying extra attention to on every job are Alabama and Mississippi. In particular, because those states require that every subcontractor that sets foot on your job be licensed with the state as a contractor. And they will shut down your job if they don't have that license. Particularly in Alabama, they'll show up on your job site, ask a random sub to produce their license. If that sub does not have that license, they will shut down your job. That's critical that you have a copy of that information in your file prior to any subcontractor starting work.
Anybody work in Tennessee? So in Tennessee, you got an electrical sub. What do you have to have for an electrical sub license?
As far as the license?
Yeah. If you don't know, it's fine to say you don't know.
Yeah, I don't know.
Okay. Are you aware of whether Tennessee has monetary limitations on licenses of trades?
Yes.
It does. And do you know what the implications are of whether your scope of work exceeds the monetary limitation of the particular sub that you put out there? Probably not. That one's as nasty as Alabama, because if you put a sub out there and you don't know what the monetary limitations of their license are in Tennessee, then your ability to get paid for that sub is limited to the monetary license at best. Arguably, the owner doesn't have to pay for the sub at all. So as bad as it is to have your job shut down, it's probably worse to not get paid for electrical sub. So the difficulty with Tennessee is that they have these they're very pro-Tennessee subs, right? And so they don't like out-of-state subs, even if they're licensed in Tennessee. And so the way they try to control that, typical of all kind of jurisdictional control, is they put these monetary limits on that. So you need to not only know that they're licensed, you need to know if their license meets the monetary limitation of your job. I had a massive bid dispute, $46 million wastewater treatment in Chattanooga over that exact issue. Ultimately was successful in that, but the electrical sub that was tendered on that bid did not meet the monetary limitation and could have resulted in the loss of a $46 million job. Even though they were the winning bidder, even though all other requirements were met. And it resulted in not only a bid dispute, it resulted in licensure actions that all had to get dealt with. So licensure is a big deal, and it's becoming bigger because we have so many general contractors that walk across state lines, and they're getting pretty territorial about it. So understand that. If you're dealing with joint ventures, which you are now, we've set up a couple of them for you, you have to understand your own joint venture licensing requirements. But if you're dealing with a sub that's a joint venture, this could be the same thing. So just because ABC Electrical, who might be a member of a JV, is licensed, doesn't mean the JV is licensed. Okay? So again, Any questions about licensure, you know, Chad is
Call us.
here to deal with that.
A couple of quick ones off of that, based on that, Kelly. What recourse do we have? Should we have a subcontractor present themselves as something above and beyond what they are licensed to do? And what do we have? We have an electrician that comes out and they're licensed for $250,000 and they bid us on a $400,000 package. We can't use them. Our cost to go to the next guy is another 50 grand. Can we go after them?
No, because you bear the responsibility before you submit that bid. So before you utilize them in the bid package, you bear the responsibility to not only get their license, but their monetary limitation.
So the responsibility lies with the GC, not on the
Right.
subcontractor.
And the only way you would have been damaged is if you have submitted the bid, because you relied on them for that.
Right.
It's actually the same thing that happened in the wastewater treatment, because my client thought that they were unlimited. My client put down that they were unlimited. In fact, they were limited to $25,000 on what amounted to about a $2.5 million electrical package.
Well, that's big.
Now, they were unlimited in Georgia, they were unlimited in Alabama, they've been licensed in Tennessee for forever, right? It wasn't intentional. But that's what's happening, is that they don't bother to go back and check the status of their license.
Okay.
It would have been ministerial for them to become unlimited, the electrical sub in that case.
Okay. Now, let's say you start the job and you're within the limits. Changes in scope.
Yeah,
Creates-
that won't put you in harm's way.
Is it
at
the
that point.
initial value of?
It's the initial value of the contract.
One question about that Tennessee job, especially around Chattanooga, there are a lot of union companies up there, especially electrical. Did that have anything to do with this monetary union versus non-union?
Had everything to do with why there was a bid dispute, because it was the union electrician was on the losing, there were 3 bids, he was on the second and the third losing bid, and so it was the union electrician that was really driving it more than the GC. So yes, he did. Probably would have been worse if they weren't already so overworked up there, but what that's telling you is that they're paying attention to your bids, whether you realize it or not. If you're out there using a non-union electrician, you can guarantee some union electrician who might be bidding on that same project is monitoring that, and they will know all about the status of the monetary limitations, and they will bring that to the attention of folks, which is exactly what happened in that case. But the bottom line is this, and this is going to shock you. The law doesn't actually allow you to rely on much of anything the sub provides. So those insurance certificates that they provide to you, saying that they have insurance, if it turns out that that certificate was falsified by the broker who sold it to them, and you didn't go double check behind to see if they actually have workers' comp insurance, then you just took over the workers' compensation insurance for them and are gonna have to pay the cost for workers' comp on all of their employees. So you need to get all of this stuff, but you want to get it sufficiently in advance that if you have any question about it, you have to actually double check behind it. And that's both that's the downside of being the GC, caught in the middle, because at the end of the day, the employer is the GC for all of it. Okay?
One more state to draw your attention to. I don't know how much work you guys currently are or will be doing in Kentucky. Kentucky's licensing is city and county based. They're not statewide, with the exception of plumbing, HVAC, mechanical, and electrical. You get a statewide license there. Other than that, it varies depending on where your project is located in the state and what city and county regulations are. I didn't put all of those in the chart. At that point, you should probably just pick up the phone and call us, and we'll let you know what they are, so you're not digging through the statutes.
And, look, it's not required, but it is, I suppose, Rice, having met with Rice and John, and for Ted's jobs, Ted, if you need our help at the estimating stage, at the buyout stage, we're there to help you. And we've moved our fee structures around so that a lot of this is flat fee, whether you even realize it or not. Benning may already have paid the fee for it within what they're paying us to do. So whether you pick up the phone call or not, within reason, depends, you know, you may not be taking advantage of something that's already in your operational budget for legal counsel, because we are your in-house counsel. We just operate on the outside. That's why all in-house counsel are overworked, because once they go in-house, people are all over them all the time. It's really no different with us on the outside. So make sure that if you have any doubt about it, you just pick up the phone. Next issue is kind of the same. I think we all know this. It's no different really than workers' comp, but I mean, these immigration laws and compliance with immigration and the various forms that you have to have, all of those are going to flow back to you if you don't get them. So the penalties will all be imposed on the general contractor if you don't have the documentation that's required by this subcontract. And the difficulty here is, I don't know how you guys double check to get all this documentation. Somebody needs to bird dog this. I mean, it's obviously, at some level, it's maybe the PM, but making sure you have the file complete with all of that is gonna be important. We've spoken to some degree already about assignments, liens,
And the important point here is, before you start, get a complete listing of your subcontractors, sub-subs, and suppliers, so you know who they are. We're gonna emphasize this some more when we talk about the liens and why that's important, but you've gotta know who's working on your job and where the potential claims could come from at the end of the job, so that you can make sure that doesn't happen. And particularly in a state like South Carolina, it's very important to be tracking that on a chart with that job for their liens, and we'll talk about that as well.
Yeah, we could spend an entire day with you on liens. Chad and I have done various flow charts to try and help you understand liens. But I think there are a couple of things that you need to appreciate about liens and lien waivers in general. The first is, anybody in this room that signs a lien waiver, okay? And I'm not gonna limit this to Georgia, but although it comes out of Georgia. If you sign a lien waiver, you need to make a note to evaluate the status of payment within 45 days after you sign the lien waiver. Because under Georgia law, if you have not been paid, or paid or not paid, 60 days after you sign that lien waiver, you are conclusively deemed paid unless you file what's called an affidavit of non-payment.
And that's regardless of whether the lien waiver is conditional upon payment, right?
Yeah.
Georgia,
Georgia is not. I mean, there's this bold language at the bottom of the statutory form. So the point is that every time lien waivers are signed, there needs to be an automatic process of tracking what's happened now with payment, right? However you put that into your system, we see this issue a lot. And you might as well do it on every one, because if you hadn't been paid within 45 days after signing the lien waiver, somebody up the food chain needs to be alerted. And if it's as simple as filing an affidavit of non-payment, which it is in Georgia, that has to be done to preserve your lien rights. There are all kinds of these little gotchas and pitfalls that exist across liens, right? I mean, the notice of commencement statute in Georgia, which comes out of a Benning case on no assignment, is important, but how you file that notice of commencement, where you file it, where you post it matters. What happens if you get a notification matters, right? So all of this lends to things like this that Chad's going to spend a lot more time on, are these flow charts. But at the end of the day, as much as these flow charts are trying to explain it to you, again, it's an area where you may have questions and you need to pick up it.
So, did I hear a question?
I have a question about the lien waiver, but from the subcontractor side, is that what I deal with mostly? When you say the date it's signed, the notary date signed, or the date?
So,
I mean, what specific date are we referring to? Because I get the argument a lot from the subs that they're not gonna sign it because of what is on the bottom saying that you've been paid. And I want to be able to explain to them, you need to sign it, this is why, your rights still are there, And I just need to know what specific date am I looking at when I go to this plan.
So there was a case on this in Georgia a year and a half ago, 2 years ago, where what happened in that case was the subcontractor executed the lien waiver, and there's a paragraph in the Georgia lien waiver where it says that you're waiving your claims through a certain date. And they put a date there, and then they signed it 10 or 15 days later. And they notarized it, and they had a date down at the bottom. Well, they tracked their 60 days from the date that they signed it down at the bottom of the page. And they said, well, we filed our affidavit of non-payment in time, or claim a lien in time because of that date. What the court said is the date that matters is the date that you put in that paragraph as when that lien is effective and what you're waiving your claim through. The date you signed it, if you backdate it, or if you forward date it, it doesn't matter. It's that date in that paragraph. So ultimately, when you complete the lien waiver, and it's for a particular pay period, and you put that payment date in there, that's the date it's going to go.
But the message to the subs that you need to give, it's a great question, is that if they don't sign the lien waiver, the only thing they're guaranteeing is that they're not going to get paid, because having their lien waiver is a precondition for the owner to make payment. But they're not waiving their lien rights. What they need to do is exactly what I just told the group here, which is they need to calendar 60 days from the date in the box Chad was just talking about. And if they don't get paid by then, they need to file an affidavit of non-payment. Now, it seems like a procedural pain in the butt, and it is, but it means that they haven't waived their right to be paid, okay? So that's their process. And if they need, referral to a subcontractor attorney, we'd be happy to give them somebody who can guide them through that process. But they nonetheless need to sign the lien waiver.
So, on your jobs, one of the most common things we hear from contractors, and tell me if you've ever seen a subcontractor that looks like this guy. I don't know. You didn't tell me. You didn't give me that contract. I didn't get that document. You didn't tell me to do that work. I know nothing. I have no idea what's going on in your job. I just show up every day. I have no idea. This is, from an administration perspective,